Yeah, hi guys. I think I'll start off in terms of just introducing myself. Uh, my name is Shyam Kapadia. I now practice as a lawyer in the Bombay High Court. Previously, I graduated from Nalsar in Hyderabad and then worked with a large firm in London. Now, before Sunita asked me today to speak to young lawyers, I considered myself a young lawyer, but evidently that's not what everyone thinks. Uh, the topic is very broad. Today, I'm going to talk to you about opportunities, skills, and challenges for young lawyers. So, I apologize in advance because I might not be able to cover everything under the sun uh, with respect to this topic. It's a very wide topic. The context is also important to this talk because there are huge changes taking place. Now, these changes are both technological and in terms of other changes that have an impact on the practice of law. Now, on the technological front, this is quite important because not much has changed in law. If you go back 2000 years and you talk about Cicero addressing the Romans, or 500 years ago when Shakespeare imagined what a trial in the Merchant of Venice would look like, there's not much that has changed in terms of how we practice law. We still go to a designated place, it's called a courtroom. We still appear before designated people who have to make a decision, and our oratory and our the grasp of the facts really is what we have to showcase. Compare that, for example, to medicine, where everything has changed in the last 2000 years, certainly in the last 500 years. That will show you how little technology and innovation has changed the legal profession. Now, this is not to say that things haven't changed. We, of course, have our online displays, we have cause lists, we have orders, all of which are available online, and they've been a massive boom, a boon for everyone practicing law. Now, COVID-19, that's what we're all here today. Otherwise, I would be in court on Friday and you would be doing something far more useful on Friday. This has been a catalyst in terms of technological advancement for our legal fraternity. I have for the first time actually participated in video conference courts. This is something that we've been talking about for years and years, but it never actually happened. For the first time, we're actually participating in them. There are also e-courts, which are something incredible, which is that anyone with an online connection can sign in and see what is happening in court. That again increases access to our judiciary like nothing else. Now, while keeping all these technological advancements in mind, I think there are two caveats that I'd like to make at the outset. Firstly, I think a lot of this technological progress will be lost the moment the courts open again. Now, this is just simply because of how things are. I think people are far more comfortable arguing in person in court rather than doing it through video conferencing. So, despite whatever people may say about video conferencing being the way forward and this is how things are going to be from here onwards, I don't think that's true. I just simply don't. The moment this COVID-19 situation is over, I feel we'll go back, and all this video conferencing and e-courts will be left in the margins again. Secondly, the caveat is that I don't think this actually, the technology has matured to the extent that it is an actual substitute in terms of having an in-person hearing. The technology in terms of the application, our internet connections, even the ease by which court officers and lawyers can use these facilities, I don't think are of a level yet that would even come close to what we'd expect in terms of an in-person hearing. Now, that's just the context and the background in terms of what the topic is and what we're currently dealing with right now. But the main part of today's discussion really is about skills, opportunities, and challenges. I'm going to start with skills, then come to opportunities, and then deal with challenges last. Uh, in terms of skills, I think this is very important because you've got to accept the fact that as young lawyers, there are lots of there are lots of new things that you can do. It doesn't have to be the way it was done earlier. And one of the main things that I want to talk about is technology itself. Now, we were talking about technology in terms of virtual courts, in terms of e-courts, video conferencing, etc. But even in your practice on a day-to-day basis, technology is something that can help you. And I feel that young lawyers in particular should embrace technology because that gives you a that gives you an edge, and that differentiates you from lawyers who may be senior to you but are not that adept with technology. Now, it's fine to say embrace technology, but then what are the practical examples in terms of how you can embrace technology? Uh, let's start with a few. I think, for example, case law research. Now, when I'm saying embrace technology, I don't mean Google search and then India Kanun what your case law research is. That's not at all what I mean. You need to get familiar with various different kind of platforms. Learn how to use the advanced search functions. Learn how to use, for example, words within a certain number of words from each other, words within the same sentence, words within the same paragraph. That will help you eventually when you want to research propositions of law and are wondering how to do it. Uh, I've lost I've lost count of the number of times that these kind of methods have helped me find some kind of judgment on a proposition of law where I thought there would be nothing, but merely because of this ease by which you can use these platforms, it does help you. So please get familiar with that. Also, I think it's important that you look at judgments even outside India. The reason I say this is that a lot of judgments are now available online. There is a lot of material available online even apart from judgments. For instance, if you look at articles written by law firms or articles written in journals, many of them are now available free of cost. So even if you don't have Westlaw, even if you don't have Lexis, start getting used to doing research using technology to help you. And please don't use it as a shortcut. Use it as something that can increase the scope of the material that you can scan. It's really easy. So many times you give research to someone, and you know that all they've done is do a Google search and then put it on India Kanun and given you the judgments. That's not what I mean by embracing technology. You need to be familiar with other platforms and other kind of areas in which you can look using this technology. So that's something that I think really should be of use. Now, the second aspect under technology and an example is soft copy briefs. This is something where I must confess I'm preaching more than I practice. Uh, it's an interesting story. I remember once I had met some friends who are not in the legal industry, and at that time I was quite interested in fountain pens. And they looked at the fountain pen and they asked me, "What do you need this for?" And I said, "What do you mean? I need to mark my briefs." And they said, "Why don't you do it on the computer?" And they couldn't believe that we all sit with papers and piles of papers and sit and mark it with pens and put post-its, etc. To them, it was just completely an archaic kind of method. And this is something which I think is perhaps law might be the last vestige of not using soft copies and having briefs as a soft copy. Now, I feel particularly as a young lawyer, if you follow this practice from now, it will pay rich dividends in the future. There are excellent software which you can look at, which allow you to do this, which allow you to have your briefs which are underlined, which can be highlighted, which can be marked, tabbed, indexed. And this, I feel, a person who is good at operating a soft copy brief is much quicker. And of course, you don't have shoulder aches carrying papers around than a person who isn't and who's part of the old school who still does it in pen. Now, I must confess, personally, I feel that in court to use a soft copy brief, at least because of my lack of experience, I find that quite hard because I'm just not quick enough. If you start off using it, I think you can be quick enough. In heavier arbitrations, though, I find it very useful. I have used it and I intend to continue using it, using a soft copy brief where all the papers are scanned, kept in the software, and you mark it, underline it. And in heavier arbitrations, particularly, it's an absolute game changer. So if you start getting familiar with this, I think it will help you in the future. Now, a third example of how technology can be used is in terms of organization. Now, if you're working in a firm, you will already have processes in place. You will have processes that have been worked through, that a lot of time and effort has been spent on to kind of ensure that they are the most efficient processes. But if you are starting off as a junior advocate or you're starting off independently, I think this will be incredibly important for you. You need to store all your drafts, for example, keep a folder of all your judgments. And many times, you have you have judgments that you've looked at once, which 2 years later you need the same judgment again, and you've again got to find it, again got to mark it out, mark the relevant paras. So I think that is something that in terms of organization, technology can really help you. I, for example, in the file name of every judgment that I store, I mention the proposition and the para number. So later on when I'm looking, it makes things easier. Even in terms of your accounts and your billing, keep it systematic, keep it on soft copy. It really helps you later on. And I think that these are again things that may take time when you're a junior lawyer to set all of it up, but it will pay rich dividends in the future. Now, that's to do with technology. Now, the other kind of skill, and I'll deal with 5 or 6 of them. The other skill is, I feel, is industry. Now, I mentioned that I was giving this talk, for example, to one of my senior colleagues, and he said that I must mention this because it's incredibly important for young lawyers. You must do even the smallest task that you're assigned. You must excel at it, because if you excel at that task, you're going to get bigger and better tasks to do. And if you don't, then I think people think that you've kind of, you're not interested, or you're not kind of dedicated, and you will get small tasks. I don't think that there's any way to escape that. From your last year in law school, when you may have been analyzing some fantastic international law point for some moot court, uh, you may feel like it's a waste of your talent to be preparing bundles for an arbitration or a list of dates for some senior advocate. But do it well. It will be noticed. It really will be. So make sure that you put in what you have to. I remember years ago when I was working in London, I used to meet 2 friends every Friday afternoon for a coffee, and I mean it really was a coffee. We'd meet after lunch, and we would discuss. One was a consultant at a top consultancy, and one was working at an investment bank. And each of us would have the same complaints. I would be running a condition precedent checklist, which was just a Word document going on for like 100 pages, and you just have to keep marking against it. The guy in the investment bank would be tied down to his Excel, just plugging in numbers continuously. And the guy at the consultancy would be preparing PPTs for his client. Now, the moral of the story is only this, that regardless of which kind of institution you join, regardless of what profession you are in, at the starting, there will be drudgery involved in what you're doing. You have to do it well, and there's no way to avoid it. You can't say that I immediately want to be deciding legal strategies for extremely high level litigation, because that's not going to happen. So I think that really you've got to accept the fact that there is a lot of grunt work required at the junior end, and that there is no substitute for hard work at all. No one becomes successful without putting in the hours. You may be brilliant, you may be extremely good at what you do, but unless you've put in the hours and unless you've done the grunt work, I don't think there's any way to become successful. Now, the third skill that I want to talk about is awareness. Uh, I think things are moving much faster in terms of regulatory and legal developments than we are used to. Uh, I was just looking at the IBC, for example. Within the last 3.5 years of its existence, it has been amended 3 to 4 times. You compare that to, for instance, your CPC, which is a 1908. It's been there for more than a century. It's been amended on a wholesale basis only 3 times in 100 years. So I think that you've got to stay abreast of whatever is happening in terms of your legal developments, and unless you do, you're at risk of giving wrong or dated advice to your clients, and that's the worst thing. And in fact, the worst thing is you may make incorrect submissions to court. So you've got to stay abreast of the latest information, of the latest development, and keep checking. Things don't stay the same. Many things change. There are RBI circulars issued regularly. There are all kinds of regulations amended from time to time. So you've got to keep looking at that. Now, your awareness should not only be legal. You also require commercial awareness and general awareness. And this helps you not only talk intelligently about commercial matters and makes client feel that you understand what their how things are from their perspective, but it often helps you from when you're making legal submissions in court. This is something that perhaps people don't realize so much. I remember years ago when I just started practice, we had a dispute between a shipping company and and our client who was who held the cargo. Now the cargo was held up by the shipping company, and we realized that this cargo was essential for was an essential component of one of the naval submarines India was building. Now, what we were worried about was that how do we show urgency? This was a serious problem because our client had been trying to negotiate for months and months. And then if you go to the court saying that there is some urgency, the court normally says that look, there's no real urgency in this matter. You sat on it for so long. So therefore, why should I get involved at this stage? What we then did was we prepared, I remember preparing it, we prepared a list of submarines and the submarine strength of India and our larger neighbor, and how we had a depleted strength, and how these submarines that we were building were incredibly important for India's naval safety. And this chart was handed over to the judge. I think I don't even know at that stage, when it became that important. I don't think the judge even thought about whether we'd been sitting on it for a while or anything of that sort. He ensured that the matter was resolved within 3 to 4 days of when the chart was shown to him. So, this is important. If you're aware generally and if you're aware commercially, it does inform the submissions that you're making in court. It helps you kind of mold the submissions that you're making in court, and it makes you make a more intelligent argument when you're arguing in court. So this is something that you must keep in mind. Be commercially and generally aware. Don't just be a unidimensional kind of person who on law may know his case but not aware of what's going on around him. Now, the fourth kind of skill that I wanted to talk about was analysis. This is perhaps the most important, because in as a counsel, as a lawyer, when you are asked to deal with an issue, you really need clarity of thought. You need to look at pleadings. You need to look at correspondence that is often lengthy, that is often repetitive. But the difference between a good lawyer and a bad lawyer is that a good lawyer is able to distill the information that is made available to him into certain key issues. Now, that distillation is incredibly important. You need to analyze what the facts are. You need to analyze what the real key issues are. Now, this won't happen overnight. You need experience to be able to do it. But you must try to distill these issues and find out what is really important for your case and what is important for the other side's case. You need to apply your mind at the very starting. If you are able to kind of distill this information at the starting, it's going to help you a lot going forward. Now, what we're seeing in terms of developments and what has happened recently is that there is a lot of trial work that is coming around. Now, this is because a lot of arbitrations, which earlier used to stretch on for years and years and years, are now made time bound. Because they are made time bound, it gives an impetus to complete the arbitration, which means you go into trial fairly quickly. And the key to drafting your pleadings and your evidence affidavit and cross examination of the other side's witness, and of course finally your final submissions, is in analyzing what issues are important to you. Based on that, you will build your pleadings, you will build your evidence, you will try and undermine the other side's evidence, and you will make your final submissions in court. This is something that you have to be aware of from the starting. If the foundation itself of your analysis is weak, no amount of artistry in terms of your pleadings, evidence, or submissions will be able to help you. You must spend a lot of time understanding the case and the pleadings at the outset. Try to analyze what your strengths and weaknesses are at that stage itself, and then see how you can build up your case for trial. Now, really, I mean, when you are a junior lawyer, you've got some time on your hands. Please make sure that you spend as much time, be almost obsessed with what your case is. Forget the 300 paragraphs that might constitute your statement of claim or your plaint. You need to look at what really are the issues that you will be asked about at the final hearing by the tribunal. uh, I think the time that you spend at this starting will save you a lot of blushes later. Now, just to put it, one of the most satisfying matters that I have done was an arbitration between an Indian bank and a foreign bank. And it was obvious that the foreign bank was either trying to bully the Indian bank or was trying to, in that sense, give it a shot and see what happens. They sent their notice. Now, from the point that they sent their notice, we sat for hours and hours trying to frame our reply to their legal notice, trying to understand what the issues are, going through the agreements between the parties. And I have not spent that kind of time on a reply to a legal notice, but we did. We then had a statement of defense along the same lines. We then questioned their evidence and gave our evidence in respect of the same kind of key issues that we'd worked out. And the reason I'm saying it's very satisfying is because eventually, when the award came out, we had one retired Chief Justice of India and two retired Supreme Court judges, both of all three of whom gave a decision agreeing with exactly what we had said in the initial reply to the legal notice that we received. So that really is incredibly satisfying. In fact, in that matter, the tribunal also granted us costs of nearly 2 crores. The other side didn't even challenge it. The other side immediately paid the costs, and that was the end of the matter. So I think that gives you a huge amount of satisfaction because you've put in the work. You've put in the work at the starting. You've then built your whole case around those issues. And eventually you realize that the award also agreed on what your reasoning was right at the starting. So, you need to apply your mind. You need to have clarity of thought. And these two, are perhaps the most important thing as a lawyer that people will look for. Now, one other skill that I want to talk to you about is adaptability. Now, when I say adaptability, I mean it as the exact opposite of being rigid. And this is particularly important for those people who intend to argue in courts. Now, this is whether you're representing your firm, whether you're representing, whether you're independently practicing, it's incredibly important to be adaptable. Uh, I think any lawyer who's had any experience in court will tell you that it is almost impossible to predict what happens once you stand up. I've really lost count of the number of times that I thought I had a weak case and I ended up succeeding. Or on the other hand, I thought I had a foolproof case and I walked out wondering how I had lost. So I think this is something that everyone will go through when you practice law. What is important is to be able to kind of read the judge and see what appeals to him or her. It may be very different from what appeals to you. You may have thought that you have a very strong point and the judge may have dismissed it, almost summarily. But some incidental statement that you made, the judge might find very interesting and might ask you about that. So you've got to pay attention to what appeals to the judge. In fact, if you're for the respondent or if you're for the defendant and the other side argues before you, you must be able to read the judge to see what is the judge worried about, what is the judge asking in terms of questions, what can you exploit when you are asked to stand up and argue. Once you have this ability to be able to read the judge and to be able to understand what is it that the judge is looking for, you must be able to also pivot your case. Now, this is what I'm talking about, is adaptability. If you are quick on your feet, and this is something that as lawyers we all aspire to be, if you are quick on your feet, you are able to pivot your entire case to whatever the judge is looking for. So you read the judge, you then have this ability to be quick on your feet, and you pivot your case. It's one of the most prized attributes, at least I feel, of a successful counsel. If you're too rigid, and that's why I said it's the opposite of adaptability, if you're too rigid or if you're too slow on your feet, I have seen a number of times where the case can slip out from your fingers because you're too slow to see either what the judge wants, or after seeing what the judge wants, not being able to pivot your case to what the judge is looking at. So this is adaptability is also between different courts. This is important. You can't be the same in every court. You've got to realize which judge likes what style of argument, which judge likes which points. And of course, if you're appearing in various courts, tribunals, in the lower judiciary, you need to understand how to present your case in each of them and what would appeal to each judge in question. Of course, this comes with experience, but you've got to keep a mind to looking at reading the judge and to see what the judge is interested in. Now, different judges also prefer different styles of argument. This is quite tough because you might have a judge who prefers a quicker, combative kind of style of argument, and you may have a judge who prefers a far more systematic approach, where one side argues, finishes his argument, then the other side argues, and you've got to see what the judge prefers. Many times you go from a combative kind of courtroom into a courtroom which prefers a systematic approach, and you get castigated merely for the fact that you interrupted the other side, etc. So you need to be aware of the fact that different judges have different views on what they would like to see in terms of arguments. So that adaptability is also important, not just in terms of your case, being able to read the judge and rebalance or pivot your case to what the judge is looking for, but also between different courtrooms to kind of have the adaptability to move from one courtroom to a completely different style of argument. So I think these are the skills. I'm happy to, of course, take questions later on, but I think that this is what I really wanted to cover in terms of skills. Now, dealing with opportunities, I think that I keep saying this to whoever speaks to me about it, that there are tremendous opportunities both in the new and old sectors of our profession. I do feel that there is a massive supply demand gap. There is a phenomenal amount of work, and I don't think that this is likely to decrease anytime soon. If at all, because of this entire COVID-19 and the lockdown, there is going to be a number of disputes that reach the court or tribunals in the days ahead. Now, the opportunities, I'll first deal with what working as a counsel or an independent advocate will get you. In terms of what the opportunities are, I think as a junior lawyer, you will find judges uh, very encouraging of you, but as long as you are prepared. I have seen lack of preparation is the reason why a lot of juniors get reprimanded in court. Judges just don't like if a junior is not prepared with his case. The feeling is that at a junior level, you should have read your brief at the very least. I have seen very often when juniors do get reprimanded, it is because they have not read the brief, and justifiably so, the judge gets upset about it. Now, all of us, let's be honest, all of us at some point have been reprimanded by judges. That's something that you're going to kind of have to learn from. If you learn from those mistakes, I promise you there is no long-term issue with respect to your having been reprimanded or castigated once. Now, there are again large areas of law as a junior that have opened up in terms of uh, growth of practice. Uh, Arbitration, I mentioned, there's a lot of arbitration happening, a lot of arbitration proceeding to trials and actually ending up in awards far more than it was before this time bound arbitration. There is also a huge growth, for example, in IBC work. Because of the IBC coming in, there's a tremendous amount of work that's happening over there. There's also an increased amount of work in the white collar crime sector. Now, you must have all read about how the two audit firms just a few days ago got let off in respect of the ILFS matter. So there is a tremendous amount of white collar work that is also happening side by side, and these are areas where juniors are getting a lot of work and should continue to do so. Now, as a junior lawyer, you may also be appointed commissioner. This is you must take it on, because I think at a junior level, this is very important. It gives you an understanding of how a trial is run, how evidence is run, how there is cross-examination of witnesses, and it at a very early stage in practice introduces you to this. You might feel that the role of a commissioner is very limited. Of course, it is. There's no doubt about it. But it gives you the experience of sitting in on a cross examination and understanding what the issues are. It gives you time to kind of think about it, to see how the line of cross examination is developing. And I think that it's something, especially at a junior level, you must take up. I've taken it up. I've done one commissioner exercise very early in my practice, and it was interesting to see how cross examination is done when you are not connected with either side. So you don't personally kind of feel invested in either side, but just from an overview, it's fantastic to watch how a cross-examination develops. Now, recently, judges have also been appointing very junior lawyers as amicus in matters where they believe they're not adequately assisted by either of the sides. This gives you fantastic experience. One, it allows you to prepare. It allows you to kind of impress the judge in terms of getting standing in that court. But secondly, it also gives you exposure to what we call betting practice, because you get to argue matters, you get to kind of be questioned by a judge, and how to deal with those questions, how to kind of prepare in advance that okay, these are the questions that I will possibly be asked. So it gives you that kind of exposure and experience. Now again, I would also highly recommend taking up pro bono matters. It again ensures that you have this continuous kind of stream of work and exposure to arguing in court. There are, of course, several ways to get involved with pro bono work, and I feel that junior lawyers particularly should take that up. You should also remember that you might not be paid for it, but people are still watching you. A judge is still judging you. You still have incredible opportunity to kind of shine. So pro bono work especially is something you should take on. There's a lot of pro bono work, especially on the criminal side rather than on the civil side, but do take it up only because it gives you what I call, batting practice. So please, that's another thing that you might look at. Now, publishing articles as a junior lawyer, you may find yourself with a lot of time on your hands in the first few years of practice. Uh, there are many kind of options available today, many of which weren't available earlier. Earlier, you only could write in journals. Now you have online legal news portals, you have blogs. Of course, a lot of newspapers now carry articles by lawyers. So you've got to use this time for knowledge building, especially in the early years. You will keep yourself occupied. You will research a point of law or a proposition in law and become aware of it. And multiple people will start to know you as an expert in this field. Uh, of course, apart from being a junior advocate practicing in court, there are various other sectors also. Law firms, as you know, are one of them. There's also corporate in-house roles. Now, currently, there are serious risks that people are dealing with, and there is a lot of scope in the corporate side in in-house roles. From the people that I have spoken to, the busiest ones currently in the last month have been in-house roles, not people in firms. Counsel, of course, have all the time in the world right now, but people who are working in-house roles in corporates. That it's just in terms of advisory. When risk increases, you want people to advise you on that risk. And currently, with the situation as it is, you will have a huge growth in in-house roles, is my feeling. Now, what other opportunities? A lot of consultants, both audit consultancies and management consultancies, are increasing their bench strength of lawyers. This is something that you can keep in mind, where you're considering what to do in terms of future growth. A lot of them want legal teams to advise them, and are taking on lawyers as junior roles, sometimes as management consultants itself, not only as legal kind of functions, but also as management functions, but with legal exposure. So that's another scope which has opened up, which you can look at. Teaching. I think teaching is an important role which is increasingly becoming important, not just because academics is becoming a very important kind of field for the development of law, but also because you will see a lot of places now are are compensating teachers for what they should be paid. It's incredible to see certain law schools, for example, are almost matching what you would get in a top firm in the first year of teaching. So I think teaching is a profession that you must look at. The job satisfaction in teaching is fantastic. I keep telling people I had taken 2 weeks off to give a course at my alma mater, and I enjoyed it. I tremendously enjoyed it, even though it was giving up 2 weeks of being in court. So please look at opportunities like that. You can take up teaching as a full-time profession, certainly as a part-time profession, but it gives you incredible satisfaction. And if you take it up as a full-time profession, there is there is now a fair compensation that you are likely to get. Judiciary, I think the opportunities in the judicial side are also tremendous. I have colleagues who've joined the lower judiciary almost immediately after graduating. In terms of judiciary, you'll see that a lot of people are joining the lower judiciary. If you have a sense of public service, if you want to do good, and you're not immediately concerned about making those so-called big bucks, you should certainly look at this area also. Increasingly, you will see that high court judges and even Supreme Court judges are those who've risen up from the lower judiciary. So there really isn't, a ceiling above which you can't kind of rise. There are people who have made it all the way to the top, having started from the lower judiciary. So you should not rule that out either. Of course, I must make it clear that yes, you will have to sacrifice in terms of in terms of making the money that you would make, say, in a law firm or in private practice. But if that's what you want to do in terms of public service, I think it's a great option available. There are also lots of roles in startups, where people want people want individuals who have an exposure not just to kind of legal knowledge but also business knowledge and expertise in both. So you have lots of mixed roles coming up in startups. uh, Again, I know people who've joined and who are quite happy over there. You've got, of course, your LPOs, you've got journals and publications. So there are various kind of opportunities available for young lawyers today, all of which you should consider in terms of what your aptitude is. Now, I will deal with challenges. I'll kind of briefly deal with it, and then I think I've got around 9 minutes left. So I'll briefly deal with it, and then I'll deal with any questions that you may have on it. It'll be easier just to deal with questions in respect of challenges, but I'll deal with what I have kind of encountered. Now, starting off independent practice is not easy. Life as a junior associate is not rosy either. In particular, the first few years, you've got to hang in there. You've got to keep yourself occupied, get as much experience and exposure as you can, and whatever work you do get, you've got to excel at it. So, yes, it is a challenge to kind of keep yourself occupied, keep yourself interested at in the first few years, but you've got to stick to it. There's really no other way. And I'm also a huge believer, and I keep mentioning this to people, that you've got to take time before you assess your career choices. I'm not saying you stick around in practice for 10 years, even though you're getting no work. That's not at all what you should do. It's not feasible, simply. But you've got to give it time. Anything that you do, whether it's joining a firm or whether it's joining practice, I would suggest you please give it 2 years before you kind of decide that this is not for me. It's very easy in the first 6 months to think that, oh, this is not for me. I don't seem to be kind of cutting any, breaking any ice over here. Let me just move on. I think you should at least give it 2 years before you kind of decide on what to do, on whether to change your career path. Now, people are different, circumstances are different, so this is not a rule that can apply to everyone for everything. But I think this is what my recommendation is, subject to, of course, your personal circumstances. Now, the other two challenges in terms of getting a job, uh, this perhaps applies more for people who are applying to firms, who are applying to corporates. Uh, it is likely to be a tough market going forward. You've got to apply to as many places as you can. You've got to speak to people who you've interned with. Keep in touch with people that you've interned with. If it might not help you actually get a job, it may help you at least indicate, whether there are vacancies or not. If there aren't vacancies at place A, whether there are vacancies at place B that they are aware of. So you've got to keep yourself plugged into the legal world. It shouldn't be that, you do an internship, you then disconnect, go off back into your law school, and have nothing, no kind of communication channel open with the people you interned with. Try and develop those relationships, because it does help you. It's at the very least, it makes you informed of what is going on in that world. Now, the other avenue which is open in terms of joining a chamber, there's no easy answer to this. I must be honest. There are a very limited number of slots available for juniors to join senior chambers as in terms of counsel practice, and there's always an excess of people applying for them. uh, my only advice would be that speak to people with whom you already have a relationship, who are already kind of impressed with the work that you're doing, who you've kind of built a rapport with, because they are likelier to take you than someone who doesn't know you at all. Also, you can ask people if they can put in, a good word for you. Suppose you've not worked with person A, but you work with person B who knows person A, then whether he can put in a good word for you, because really it's not easy. There isn't kind of an established method for application, etc. If someone does put in a good word vouching for you, it does help. Now, I think the last challenge that I want to talk about before I take your questions is a really important one, which would apply for a lot of y'all, and I have been asked particularly to speak about it. Uh, is how difficult it is for women in the profession. Now, I don't think that there is any point in kind of arguing that no, it is the same. It doesn't make a difference one way or the other. Yes, it is much harder. Perhaps it's much harder as a counsel practicing rather than in a law firm. but it is something that is a challenge, especially for the many talented women lawyers that you see. So I think that, again, the solution is you've got to stick at it. There are incredible success stories also of women who've done very well. It's not that there is some kind of glass ceiling or some kind of something that prevents you. It is tougher. There really is there is still a remnant of it being an old boys club, although I hesitate to call it that. It's not easy, but you've got to stick at it. You've got to kind of uh, you've got to benchmark yourself against those success stories and see kind of how they've done so well. So I think that may apply more for people in counsel practice rather than people in firms. But yes, it is tougher, and that is one challenge that our profession has been slow to kind of accept and overcome.
Highly voted question is, sir, it is quite difficult for fresh graduates to land up a job slash trainee associate. Recruiters prefer the experienced, but if the youngsters aren't given an opportunity, how would they be encouraged to pursue their career at law? Because only if given an opportunity, we would learn the practical aspects of law and understand how the particular area we're interested in functions.
Okay, so that is a really good question. Let me try and address it by telling you that you've got to recruiters are more interested in terms of people with experience. That's how it is. Um, you've got to apply directly to the HR departments of either corporates or firms, because freshers normally go in through that route. So I would suggest, if you're speaking to recruiters as a fresher trying to get a job, that's perhaps not the best method available. You've got to kind of directly go through the application process that firms may have or that corporates may have. A recruiter may not be able to help you so much at this level.
Uh, the next is a career related one also. Could you please enlighten us about the importance of doing LLM and solicitors? What do law firms usually prefer when it comes to hiring freshers? Which is better?
Okay, that's a very interesting question. I think certainly the fact that you've done your solicitors makes a huge amount of difference. The reason being that solicitors is an incredibly tough exam to crack. If you've cracked that, most people, it opens the door. Most people will think of you as someone who certainly deserves kind of a shot at an interview. LLMs, perhaps not so much, because LLMs, there are lots of people who've done LLMs, nor does it kind of have a stamp that, okay, this person is excellent at what they do. Whereas I think solicitors is still there. Professionally, it makes little difference whether you're a solicitor or not, but to open the door to getting a job at a firm or a corporate, I think solicitors is far more helpful than an LLM.
Okay. Is it compulsory to do a 3-year clerkship under solicitor to be eligible for the solicitor's exam in India and UK?
I think the position has changed. When I did the QLTT, it was compulsory to do a 2-year clerkship. But thereafter, I think there's some QLTS, and the position may have changed. I remember speaking to someone who said that you need not do that any longer, and you can just give a few exams, but much tougher exams, and then become a solicitor. So you'll need to look at that online. At least at my time, it was compulsory.
Please help us to know the procedure to get appointed as commissioner.
Okay, so that's not that difficult. You've got to speak to, if you're really interested in it, you can find out which judge is hearing suits. You can speak to the associate of that judge and indicate that you are interested in being appointed commissioner. They maintain a register of people, and eventually, when you become senior and you want to your name off the register, you have to again do the same process. Go to the associate and tell them that, look, I really don't want to take any more. So you can do that. It's not that difficult.
One more question: what are the pros and cons in working with the litigation team of a law firm versus working in the chamber of a counsel?
Okay, that's a fantastic question. Yes, so in a litigation team of a law firm, I would always recommend to anyone who asks, please start off by working in the litigation team of a law firm. before you jump into counsel practice. I think it makes a huge amount of difference in terms of the exposure that you have, the kind of ability that you have in terms of knowing people, knowing how the procedures run, etc. The difference is, one, in a litigation team of a law firm, you will be assigned a large amount of work, you will be paid, whereas in the chamber of a counsel, you've got to kind of depend on work coming in. You've also got to accept that you are not going to be paid in terms of a salary from your senior. So there are differences, but I think one leads to the other. You should start off, if you want to become a counsel, you should start off in the litigation team of a law firm, kind of work there for 2 or 3 years, get your head around how the processes work, get your head around how things are expected from a counsel, because you'll be dealing with counsel, you'll be on the other side dealing with counsel. So when you cross over, you know what is expected from you when you are working as a counsel, and what the firms kind of like, what they don't like. So that's something that you should kind of have exposure to.
Another question is, as you mentioned about in-house roles in corporates or companies, could you please share some information with regards to the growth and the roles available, especially to junior advocates with 1-2 years experience?
Well, if you have 1 or 2 years experience, I think you will have a much better chance than a fresher in joining corporates, because corporates do prefer people with some degree of exposure. I may not be able to really help you in terms of which corporates have which roles, etc. But all corporates tend to have legal departments, and the legal departments are growing in that sense. It's not something where it's a job that is reducing in importance or reducing in numbers. So you've got to speak to either a recruiter, since you have some experience, or to speak directly to corporates that you may have worked with. A lot of corporates kind of absorb people who are working in firms but who want to change in terms of their work-life balance, and who then move on to corporates. So you've got to kind of speak to either a recruiter or directly corporates that you've dealt with, and see whether they've got roles available. But if you have 1 or 2 years experience, that's exactly what they look for, if not more.
After joining a law firm or counsel chamber, after say a few months, how should one assess their growth in terms of knowledge and exposure?
After a few months, that's what I talked about right now. Don't assess your growth after a few months. I don't think that's a smart idea at all. Give it a year, give it 2 years, uh, and then assess your growth. I don't think that assessing your growth within a few months is an ideal kind of scenario. All right, then I'll answer. If you assess your growth after 1 or 2 years, if you're in a law firm, you should see the amount of responsibility that you're getting increase. You should see the amount of supervision decrease. So if people are comfortable, for example, with you addressing correspondence without having looked at it, or comfortable with you kind of drafting your pleadings as a first as a first draft, I think that is what you will see as progress. In a council chamber, after 1 or 2 years, you should be getting work independently or with your senior. You should be getting smaller matters to argue. You should be getting to open your mouth in court more and more, because that is what eventually will kind of assist you in being a successful counsel. So don't assess it after a few months. Assess it after a year or two, and this is the manner in which you would assess it.
Okay. There's a question about recommending good books for budding lawyers. Can you recommend any good books for budding lawyers?
You've got to. I mean, depends what your interest is really. I must confess, I much prefer reading non-fiction, non-legal work, non-legal, non-fiction books rather than books about law. But I'll tell you what, every kind of field has a book that, for example, if you look at Admiralty, there's Mason. You can kind of swear by it. You read it and it will give you some degree of exposure. So you can read up commentaries if you want, but again, try and be multi-dimensional rather than unidimensional. Don't focus only on law. You should be generally and commercially aware of other aspects also. So don't. It shouldn't be that your entire reading is only legal. That's not what I think it should be.